Howdy, this is Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas. I help folks who've been accused of a crime in Houston, Conroe, the Woodlands, and that general area. And today we're continuing our short lecture series on the rules of evidence. Today's rule is Rule 201. That's right, we're done with the 100 series. It ends at 107. It doesn't go to 110. It's not very nice and neat like that. It just stops at 107. Next one up is 201. What happened to Rule 200? We don't know. There are no 200s. They started at the 01. So anyway, Rule 201 is about judicial notice. And judicial notice is when the judge removes an issue basically from contention at a trial. The judge, instead of you proving something to be true, you just ask the judge to basically tell the jury, yeah, everybody knows that's true. We're not going to argue about this anymore. And so there's two different ways, or two different types of judicial notice, or really there's two different types of facts that a judge can judicially notice or find to be true in some official sense. So the first is legislative facts and the other is adjudicative facts. Okay, so what's the difference? A legislative fact, and let me quote the case law on this so we're not getting this wrong. This is what the Court of Criminal Appeals said in Emerson versus State, 880 Southwest 2nd, 759. We are authorized to take judicial notice of any scientific fact which is capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. Okay? And lawyers don't like to hear that just in general, whose accuracy cannot reasonably be questioned. Like everything can be reasonably questioned. But there are some things we kind of agree on, like gravity. Okay? Everybody basically believes in gravity, and, you could maybe do notice of about that kind of a scientific fact. When things get dropped, right, they fall. That's so obvious. Nobody's going to ask for judicial notice on that. But where it comes up is scientific testing. And so here's a case on what's called the HGN, or the horizontal gaze nystagmus. It's an eye test done by police officers. And here's what the court said. Legislative facts are those which help the tribunal to determine the content of law and policy and to exercise its judgment or discretion in determining what course of action to take. Legislative facts are ordinarily general and do not concern only the parties. So a court couldn't take judicial notice under this section of 201 of like that the HGN was done, perfectly on this occasion. That'd be up to the jury eventually to decide in a criminal case whether the HGN or the eye test was done correctly on that occasion, and then they get to determine the weight of that. The judge can't just say, yeah, that test's great and it's something you have to listen to. Ultimately, it's up to the jury. But the judge could say that, well, we think this test, if done correctly, is an important and reliable scientific test. And so that's what the court did in this case from 1994, Emerson versus State. And another good example of this is Bloodspatter Analysis in Holmes versus State from Waco in 2004. The Court of Appeals of the Waco Court approved judicial notice of the validity and reliability of blood spatter analysis. And it's important to know that's a blood spatter, not blood splatter. Splatter is what happens when you drop something and it goes everywhere. So I get why there's confusion there, but there are no such thing as blood splatter analysis. There are only blood spatter analysis experts out there, and all my blood spatter friends would, here's a shout out to you on making sure everybody knows the difference there. Anyway, so going on with Rule 201, when can you do this? When can you ask for judicial notice of something? Anytime prior to the end of closing arguments. It says you can do it at any time during the trial. Now, those legislative facts that we talked about, saying that a certain scientific testing kind of thing is reliable and can be used, or take judicial notice of it. Well, that is not what we're talking about under Rule 201. 201 is adjudicative facts. So this is normally like parts of the geography of the county, like, for example, that the Woodlands Mall is inside Montgomery County. You could technically ask the judge to take judicial notice that this location is within Montgomery County. So when adjudicative facts and judicial notice come up, that is typically done related to geography when it comes to a criminal trial. And when it becomes more important is when the prosecutor forgets to say that, yeah, did this event, the witness, did all these events happen in Montgomery County or in Harris County or Brazos County or whatever it is. If you forget to do that as a prosecutor, you could actually ask the judge to take judicial notice at any phase of the proceedings, even after you've closed your evidence, that the places you talked about during the trial were in there. Now, judges really are not going to bend over backwards to do that, and you're in a tight spot as a prosecutor if you're in that spot. But, the defense attorney in the case is going to be objecting to what's going on there. But it could be done, I think, under these rules and under Rule 201. That would be an adjudicative fact. It would not be a legislative fact, meaning it's not some part of the law or science. And we'll get into taking judicial notice of laws and maybe the laws of other states, and that is the next lecture, Rule 202. But as far as 201, that's judicial notice. Let me say one more example, just in case. So you can actually take, in civil cases, they do this judicial notice sometimes, like for weather, like you could consult an almanac that can't reasonably be questioned, that this almanac keeps track, did it rain that day, did it not rain? You could maybe take judicial notice of things like that as an adjudicative fact, but that's, again, really, really rare. And then one more note for my civil buddies out there, my civil lawyers. This is about instructing the jury. Instructing the jury in a civil case, the court must instruct the jury to accept the noticed fact as conclusive. Okay, so if you get judicial notice on some fact in a civil case, the jury doesn't get a choice. They have to follow it. In a criminal case, however, the court must instruct the jury that it may or may not accept the noticed fact as conclusive. So even if the court says, yeah, it was raining that day, or yeah, that place is in Montgomery County, that Woodlands Mall, yeah, that's in Montgomery County. Well, in a criminal case, the jury is free to decide, well, no, it wasn't. We don't think it was. That's not going to happen, but technically it can. And that is so important because in a criminal case, it is somebody's life literally on the line, their well-being, their future. If it's a felony, their ability to vote, have a gun, all sorts of things are on the line. And our system in America protects the rights of people against the government. And in a criminal case, there's every opportunity for the defendant to have a fair trial. And this is another example of how the legal community supports that. And that's a really important thing about just being an American in general. I mean, our Constitution gives us all most of these important rights, like the 5th and 6th Amendment, even the 8th Amendment right against cruel and unusual punishment. Very important. And glad to be sharing this information and the rules of evidence with you guys. We'll see you next time.